Okay, but that doesn't happen here.
So I have
That's a motion for downtown. That's a motion for downtown. Today, all they have to do is give me reason to believe that on August 10, 2025, you had a weapon and you weren't carrying it legally. It was concealed weapon. Had he followed my bond condition, he wouldn't have been in the shootout and be in a wheelchair right now. Mr. Jadala, what do you got?
wrong piece.
BRU?
evidence.
I've got it.
And there was never developed in 6 appeared not to have been sprung. On me, 11 told the runner, I didn't read sprung, whether I would be reserved momentarily. I remember the complaining witnesses were here. They approached me, they told me they saw him walk out. To ensure, I brought them inside the courtroom, see if they could identify him. That took them around. They've been dismissed. I have no reason why Ms. Brown left the courtroom.
Okay.
Sure.
All right, we'll issue a bench warrant.
Is that how wonderful they are? And thank you for putting Scott on the record. I appreciate that.
No problem.
We have Kathy right here for the adjournment.
Mr. Hadley, I'm ready on Woods.
Your Honor, we are here today for rape three for element.
Thank you.
Your word is a breach to obtain discovery in this matter. Then we just need to address the reading.
Yeah, would you waive formal reading?
Respectfully, Your Honor, I'm going to ask for a PR bond in this matter with the standard conditions of no alcohol, no drug use, without a valid prescription at this time.
All right. Are you working, Mr. Woods? Where are you working? How long have you been employed there?
I'm working at the Oakwood Park Apartments as a leasing agent.
Yep.
For about a month now.
Okay. Where'd you work before that?
Worked at a science salesman at Science in One Day in Ann Arbor. I was a receptionist slash sales consultant.
Okay.
Well, we still stay with the allegation stage only. My client has taken a very proactive situation. He's been refraining from any alcohol use.
Good.
He's been actually actively engaged in 12-step meetings.
Good. Beautiful.
Just want to let the board know.
Beautiful. Beautiful. Yeah, get ahead of the game. All right, Mr. Woods, court dates can be 12/3, 9:30, all right? 10 a.m. Now, I'm going to put you on a personal bond. First two conditions are pretty obvious. Number one, stay out of trouble. Number two, be in court. Third condition, do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. That rules out alcohol and marijuana. You can live with those rules? Raise your right hand. Swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw that up. Any questions? Just have a seat till we get your notice.
Your Honor, thank you for sneaking us in.
Give me a name on the exam.
Mr. Jones.
Jones. Waiver? All right. Your appearance, counsel.
Good afternoon,
Good afternoon, Your Honor, neighbor for the Defendant Service of Detroit. Mr. Richards, please say 850 10 Mr. Jones, who is seated to my left. You know, please state the name.
There you go.
Thank you, Mr. Jones. Go ahead, counsel.
Please state and friends that for examination, it's my understanding that the order ready to proceed as that happens.
Correct.
We are, I have advised Mr. Johnson is right, but Jimmy Anderson and that right, he wishes to wait for us.
Good. All right, Mr. Jones, is that true? You understand your rights?
Without understanding, being my best interest, Your Honor.
Okay, but you understand that you've got a right to a trial. You understand you have different kinds of trials are available. You've got an attorney to advise you. You understand all that? Right. And you understand the purpose for the exam?
Can you address me?
Sure. If we hold an exam, the prosecutor has to prove two things. One, that a crime was likely to have happened, and two, that you were likely involved in that crime. It's a probable cause burden. It's not a beyond a reasonable doubt, okay? So it's basically reason to believe. You understand that? If I answer both those questions at the end of the exam with, yeah, there's reason to believe, I'm going to send it downtown. By waiving, you're just saying, let's just go downtown and deal with it there. You understand that?
Any issues on CCW?
That's all I've got is one count, carrying concealed weapon, from October 10th, or excuse me, August 10th.
reason to believe that I let, just the honorable judge, know that I believe that my arbitration should be legal.
Okay, but that doesn't happen here.
So I have to.
That's a motion for downtown. That's a motion for downtown. Today, all they have to do is give me reason to believe that on August 10, 2025, you had a weapon and you weren't carrying it legally. It was concealed weapon. That's all they have to do. You understand that? And you understand by waiving, you're just saying you're not gonna make them do that. You're gonna make them go downtown and prove their whole case. All right, does anybody disagree with the way I explained the process? You want to clarify anything? Okay, so understanding that, are you waiving today? All right, and you're doing that because you think you're taking her advice, that it's the best thing for you to do? Okay, all right, so I will accept the waiver. You satisfied that it's knowingly, voluntarily made?
Yes.
All right, so I'll accept your waiver. Your next court date is gonna be next Wednesday, 9 a.m. downtown. Understood? All right, anything as to bond? Let me figure out what it is first and make sure we're all on the same page. It looks like it's a 10,000, no, that's PR.
The court increased bond recently.
Do you know when that was?
The 15th.
Oh, here we go. I still can't find anything for,
I held it on as 20,000 10% based on RFA.
conditions?
Judge not possess any weapons, firearms, or ammunition.
Oh, okay, yeah, this is the one we got the report in.
VicPia, a video enhancer, is an AI video quality enhancer.
Yeah, we got an incident report that said that he was involved in some other incident on October 8th, and that there were firearms involved. Okay, all right, so now I think we're on the same page what the bond is now.
Yes.
All right, go ahead.
Your Honor, I would ask the court to consider a reduction to a personal bond with house arrest and a tether. Mr. Jones, obviously he's in a wheelchair today.
Mhm.
He was, shot
Yep.
multiple times. He is receiving at least some treatment at the jail, but not to the extent that he should be. He's supposed to be undergoing physical therapy so that he will be able to walk again.
Mhm.
That's not happening. I understand, that the people are gonna talk about another case that could potentially arise, but at this point in time, Mr. Jones is not charged with anything other than the CCW that's before the court today. So I would ask the court to consider a personal bond with house arrest so that he can go to his physical therapy,
Right.
and get medical treatment that he needs. He does have a place to live. His girlfriend's mother indicated that he could stay with her. There are other places he could live, like given stairs and whatnot.
Right. Okay,
So I am asking the court to consider that reduction with those conditions.
okay.
Your Honor, and defense counsel is correct that there is another pending case.
Out of the October 8 incident?
The defendant has not been charged at this time, however, he is currently being investigated by the police as the aggressor in the shooting. Additionally, at the time that alleged incident occurred, the defendant was under the court's bond conditions, which prohibited him from being in possession of any weapons. As you know, Your Honor, the court speaks through its orders, and the defendant clearly disregarded that. So based on that, I'm going to request $100,000 cash, no 10% bond for this individual.
All right.
And Judge, I understand.
My apologies. In regards to the medical file, we would have no objection to the court labeling the file as a medical.
And
Go ahead, Ms. Castle.
20,500. I don't know if the people have been given any new facts that the court was not made aware of at that time when the court made that decision. But I am asking the court to consider the personal bond, given the health condition that my client has. It's also my understanding that the other individual involved regarding that overbeating has in fact been. The fact that my client has not at this
Yeah.
is telling. So I would ask the court to consider that as well. And I also failed to mention earlier that he does have support in the courtroom. His grandmother and his great aunt,
Mhm.
his girlfriend is here. His girlfriend's mother was here but had to leave. And Reverend Robert Olive is here, who is going to be mentoring him.
Good.
Programs out of Detroit that
Right.
he's involved with.
Okay. Thank you. All right, so while you two were both talking, I found my notes. I'm the one that increased the bond to 20,000, 10%. And this is gonna come off snarky, and I'm not trying to be snarky or sarcastic. But had he followed my bond condition, he wouldn't have been in a shootout and be in a wheelchair right now. He can't follow bond conditions. I'm not gonna let him out on a personal bond again. So I'm gonna leave the bond exactly as it was when I set it on October 14th. It's 20,000, 10%. Good luck downtown.
Thank you, Rob.
All right, appearances for the People versus Todd Young.
People here are two collective hearing on the people here for the.
Thank you, Your Honor. Hey, Josh Advocate on behalf of Mr. Todd Young, who's joining us from Wayne County Jail via Zoom. Mr. Young, can you hear me?
Yes, I can.
Please state your name for the record, sir.
Todd Wilson Young Jr.
And Your Honor, as stated, date times of retrial, we have reached a resolution in this matter. Plea form has been presented to the court. There are 4 pending misdemeanors in this matter. There's a resisting obstructing police officer, a false report to officers, a domestic violence, and an assault and battery. My client will be tendering a guilty plea as to the domestic violence charge. The other 3 misdemeanors shall be dismissed.
All right, that's not what the plea agreement says. Plea agreement says count 2 and count 3 would be dismissed. What's count 4?
But I'll also include that. See that on file.
It's written out on the document, Your Honor. I'm just reading off of it.
And I don't have a file, so I can't confirm what the complaint says.
So why don't, since I misstated the plea offer, Your Honor, what has been presented to the court?
I've got a plea agreement that says, plea to domestic violence, count 1, 750.812. There's some sentencing recommendations, including a 769.4A, and then dismiss count 2 and 3. You got it?
Yes.
Wonderful. Hold on a minute, let's see what the complaint's got.
Hey, how's that New Year's resolution going? What are you talking about? You know, that YouTube channel you say you're gonna start? Well...
The complaint's got 4 counts, so Mr. Leckie, you're saying dismiss all?
Yes.
That's fine. All right.
It's still the tendering the guilty plea as to domestic violence, the other 3 charges will be dismissed.
Correct. Correct. All right, Mr. Young, did you discuss your rights with Mr. Hadley?
Yes, I have.
You understand your rights and the options those rights present?
Yes.
Do you understand the possible penalty for the charge of domestic violence?
Yes, I do.
Understanding all of this, are you pleading guilty to that charge freely and voluntarily today?
Yes.
So just a correction, on the complaint, count 3 is the domestic violence. So we're gonna take a plea to count 3, dismiss counts 1, 2, and 4.
Yeah.
That's all right.
Count 3? What is that?
Yes,
I
Mr.
was,
Young? Is that
yes,
you
sir.
talking? Yeah, Mr. Young, the court was just clarifying, the charges, or all the 3 charges as we discussed are being dismissed, pleading guilty to domestic violence. The only confusion was as to which one was 1, 2, 3, and 4.
Understand?
No, I really don't understand.
All right, you're gonna plead guilty to domestic violence, yes?
Yes, I will.
Okay? All the
So
other
much,
charges against you from this incident date would be dismissed. That means
Okay,
an
thank-
assault and battery, count
Yes.
4, count 2, which is interfering with a crime report, and count
Yeah.
1, which assault, resist, or obstruct attempt of a police officer. So those 3 go down when I take your plea to domestic. Understood?
Yes, sir. Yes, sir.
Okay. And you understand the possible penalty for the domestic violence charge?
Yes, I do.
All right. And you understand your rights?
Yes, I do.
All right. Understanding all this, are you pleading guilty freely and voluntarily?
Yes.
On August 19, 2025, were you in the township of Van Buren?
Yes, I was.
And did you lay your hands or put your hands on Alyssa Millspaw without her permission?
Well, I really didn't put my hands on her, but I was defending myself. There was a male there.
Okay,
We
stop
had a,
right there. Stop
we had
right
a-
there.
Okay. I'm sorry, sir.
It's okay, if you're certain that you act in self-defense, the court is not taking your plea, then we're setting the case for trial.
No.
Okay, so what he's asking is, on the date and time he stated, did you make an unwelcome or uncommitted touch?
Yes, I guess so. Yeah, fine. Yes.
No, seriously, there's no I guess so's. This is either you did or didn't, no one wants you to plead to something you didn't do.
Yes. Yes.
This is where we got in the previous
Right.
time, and this is why it was adjourned to this date. was-
Mr. Young, let's do it this way. Tell me what happened between you and Alyssa on that day.
We were arguing. She ran outside. I sat at the table. I heard voices outside. I opened my front door, walked on the front porch. There was a male out there talking to her. He turned around, acted very violently, grabbed me by my leg, pulled me down my steps. I fell on top of my grill where I burned my arm right here. I have the
Okay.
scars on my arm still. And I got into a fight with him. I chased him down the street. I fought.
What about you and Alyssa? What about you and Alyssa?
I saw Alyssa sitting at the corner by the stop sign. I chased the guy down the street, and then I turned to the right where I saw the police officers coming down the street in their car.
Okay, so nothing between you and Alyssa.
No,
Okay, you never
No.
threatened her, you never touched
I never
her.
threatened her at all.
We'll set it for trial.
Mr. Young, you're having a trial.
Mr. Young, you understand that when you set a trial, you have 2 options. You can set it for a bench trial, which means I would hear the case, I would make all the decisions, or you could set it for a jury trial, which would mean the jury would decide the facts and I would still make the decisions based on the law. Do you understand the difference?
Yes.
All right, what do you want to schedule?
Well, I got some other things going on right now. I'm being held on,
None of that
Um,
matters to me. I
okay.
just need you to tell me what you want and then we'll figure out when we can do it. You want a bench trial or you want a jury trial?
What's the difference?
I just told you, a bench trial, all the decisions would be made by the judge. Factual decisions like, did you touch her, did you not touch her? Those would be made by me. Legal decisions, does this law apply or does that law apply? Those would be made by the judge. With a jury trial, the factual decisions are made by the jury, the legal decisions are made by the judge. Understood?
I'm not sure it is.
I'd just like to get it over with, honestly.
That doesn't help. Do you understand those options I explained or not?
Yes, I do. I understand.
Okay. Then you need to make a decision. Do you want a bench trial or a jury trial?
A bench trial is fine.
All right. Heather, when can we schedule a bench trial?
The December 3rd date, cause Josh is here with us.
You want to do that at
1 o'clock?
11?
I think that would tie out this thing today.
What's Josh saying?
He's worried that there'd be too much morning stuff hanging over at 11.
Okay, we can do 1 o'clock.
All right, Mr. Young, December 3rd at 1 p.m.
Okay, thank you.
All right, we'll see you then.
All right.
Mr. Young, can you tell the jail if they can put Mr. Webster on? You're done. Walk back and tell the deputy to get Mr. Webster.
Okay, all right,
Okay, thank
hold on,
you.
Mr. Young,
Oh,
hold on,
hold on.
stay where you're at, the attorneys are still talking here.
We've had now, this is about our stop, the exact same issues. We've gone over this, I would say at length, and we're not making any progress. I have reasons to believe maybe Mr. Young is not understanding what the difference between a jury, a bench trial, and what his rights are. Because he, within the past few minutes, obviously, we've had a couple of about faces. I don't know if, again, he's being held at Wayne County, we just go ahead and get a competency evaluation working.
I think that's proper.
All right, I'll order a competency.
No, the dilemma, but I think in this case, it's probably necessary.
All right, Heather, got that?
A routine court hearing suddenly became tense when the defendant struggled to make a simple decision. After listening to repeated explanations and delays, the judge